You can't pick out Eknath Shinde and say, now you become the chief minister. It's like saying that the party is registered with the Election Commission. The leader is as communicated to the Election Commission, but I, as governor, will pick up another leader contrary to what is communicated to me. The leader continues to be Mullah. In the instant case, it is undisputed that on the 30th of June, Uddhav Thackeray was the leader of the Shiv Sena political party. However, the governor extended an invitation to form the government of Shinde, whose only claim as on 30th June was that he is the leader of the majority faction of the Shiv Sena legislature party. The governor, as on 30th of June, did not and could not have recognized Mr. Shinde as the leader of the Shiv Sena political party. As submitted above, a parliamentary democracy only recognizes alliances between political parties and not an alliance between a political party and a faction of the legislature. I've already said that. As submitted above, therefore, the governor's action of inviting Shinde Mullahs to form a government illegitimately recognized an alliance between a faction and Shiv Sena legislative party and the BJP, which is constitutionally impermissible. The governor's decision is liable to be set aside on this basis. Further, the respondents have failed to deal with the petitioner's reliance on 164(1)(b). Let's leave that out for the moment. Let's leave out the other things. Then, they relied upon Kuldeep Bishnoi. What I have now done is, I've given our lordships para 62, what Kuldeep Bishnoi held and how it's wholly irrelevant, so that I don't have to, unnecessarily take your lordships. I've put it out in the note itself. And then Shivraj Chauhan. Then come to respondents now. This is the next topic. Next topic is page 20. Item C, respondents based on undisputed facts on record have incurred disqualification under 2(1)(a). Petitioners have shown that the undisputed facts of the respondents, namely so-and-so, passing a parallel resolutions. I will let Dr. Singhvi actually deal with this because originally also he had dealt with it. So let's sort of... Then C1, repeated, now respondents contend that now repeatedly saying that there's been a split and you have not merged is of no consequence because there is no one, this is no one's case. I have never argued that I have split from the political party. I'm just quoting from the transcript, how useful this transcript is. I have never argued that I have split from the political party. We have never argued that we needed to merge with other parties. Those were defenses under the 10th schedule. Our consistent and continuous argument has been that we are within the Shiv Sena, represent the rival faction. Now he's accepting it. Representing the rival faction, which ought to be recognized as a political party. Now, this is the cat is out of the bag. Now he's saying outside the constitution, outside the principles of constitutional law, a faction in the legislative party should be recognized as a political party. Without going to the election commission, without registering yourself, what political party? So I'm quoting only from the transcript. And has now been recognized as a political party is in question in this matter. Then, I've said the contentions of the respondents never claim that they're a faction of the legislature, but they are a political party itself is totally misconceived. After the deletion of para 3, a faction, I've already said that. Effect of deletion is that a faction, as soon as it indulges in prohibitive conduct under para 2, would have no defense available. So they have no defense available. Respondents' justification in substance is that they are the majority faction in the legislature party, which is no justification in the eyes of law. Respondents cannot avoid the inevitable consequence of disqualification. Legality of respondents' actions is to be tested based on substance and actual effect on the impugned acts. I will not deal with it. Now, let's forget about this election commission for the moment. Now come to C3 at page 22. Erroneous conflation of legislature party and political party. I just don't understand on what basis my learned friend made this submission. The whole purpose of the 10th schedule is to talk of the legislative party and the political party as separate entities. and to prevent acts which would amount to disqualification. That's the whole purpose. Whereas the Constitution doesn't recognize that. Even the Representation of People Act doesn't recognize the legislature party. It is only in the 10th schedule because you wanted to prevent acts of disqualification. In furtherance of their smokescreen defense of being in Shiv Sena, the respondents have repeatedly asserted that there is no distinction between a legislative party and a political party. And again, quote from the transcript, we have consistently said so, that a legislature party is integral and originally connected and co-joined to a political party. What's the basis of this submission? And I still say, I am the original political party. So first he says, I'm a faction. Now he says, I'm the original political party. Because that faction should be recognized by the governor as the original political party. Now they are presuming that this is only a rival faction. He just said that it's a faction within the legislature party and not a rival faction within the political party. Whereas your lordships have time and again said, you can't segregate the two. A legislature party is also an extension of the political party. That is how it has been right through the whole artificial distinction which has been drawn, that is that the legislature party who did it and the political party had nothing to do with it. I have never ever said that the two are different. Our argument right through has been the decision of the legislature party has the authority of the political party. Where does he get that from? Decision of the legislative party has the authority of the political party, unless he says, my faction is the political party. Thus, in substance, the respondents contend that the faction representing a majority of the legislature party is deemed to be the political party without regard to the political party which has been registered by the Election Commission under 29A. A fortiori, therefore, without referring to the original political party which has been registered with the Election Commission, the majority faction contend that they can hold themselves out as a political party and take actions within the House, dehorse the political party on whose ticket they were elected. It is submitted that a majority faction cannot claim that they are the political party registered with the Election Commission under 29A of the Representation of People's Act. There is nothing in law which allows such a claim to be made. Distinction between the legislature party and the political party is reflected in the provisions of the 10th schedule. Submission of Eknath Shinde group is contrary to the clear provisions of paragraph 1 and paragraph 2 and the explanation. I have read it to your lordships for this. I will not trouble your lordships with that. Then I will come to Nominal para 83, if the respondent submissions were correct or were to be accepted, it would create chaos within the political system with functions within the scheme of the Constitution as provided for in its various provisions, including the 10th schedule. So, Mullahs, now come to C4. I will leave the rest, Mullahs. Now, Mullahs, your lordships will remember all this happened much before the matter went to the Election Commission. Because there they moved on 19th July. So, Mullahs, all this is so per se unconstitutional. Now come to right to dissent. The respondents have claimed that the 10th schedule cannot be used to stifle dissent within the party, and definitely internal dissent does not amount to voluntarily giving up membership of the party. Well, this whole argument was raised in Kyoto in the context of Article 105 of the Constitution. Not in any other context. And was rejected. And 105 of the Constitution, I'll just quickly read it to your lordships. It says, subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. Rejected. Why? Because you are a representative of the political party and bound by the discipline of that party. You have no independent right. Unlike Parliament in England, unlike the Senate and the House, and unlike European Parliament. Respondents have claimed the 10th schedule cannot be used to stifle dissent. Then at the outset, it is respectfully submitted the said contention is in complete violation of the decision in Kyoto, where this court specifically considered and rejected the argument that provisions of the 10th schedule violate the freedom of speech and conscience of the legislatures. It was held that people have grown distrustful of the emotive political exaltations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. This court is distrustful of that, is what Quixote says. The 10th schedule, it is urged, negates those very fundamental assumptions of parliamentary democracy, of freedom of speech, of the right of dissent, and the freedom of conscience. This was urged by Mr. Jethmalani. It is urged that this unprincipled political defections may be an evil, but it will be the beginning of much greater evils, of the remedies graver than the disease itself were adopted. 10th schedule, they say, seeks to throw away the baby with the bathwater. So, Malas, all this I don't have to go through. And then, Malas, this went on. I will not trouble your lordships. Kindly come to para 44. Huh? Para 44 is what. But a political para, page 27, functions on the strength of shared beliefs. Its own political stability and social utility depends on such shared beliefs and concerted action of its members in furtherance of those commonly held principles. Any freedom of its members to vote as they please, independently of the political party's declared policies, will not only embarrass its public image and popularity, but also undermine public confidence in it, which in the ultimate analysis is its source of sustenance. And then, Malas, Malas, para 47, Malas, this is a quotation from Rodney Brazier. Once returned to the House of Commons, members' party expects him to be loyal. This is not entirely unfair or improper, for it is the price of the party's label which secured his election. Now, Malas, this loyalty is for a price which has secured him the chief ministership. If I can put it, Malas, differently. Then, Malas, para 49. Malas, the highlighted portion. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful of the emotive political exaltations that such floor crossing belong to the sacred area of freedom of conscience, or of the right to dissent, or of the intellectual freedom. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation have been the bane of the times. This is recognized by a constitution court. Above certain theoretical assumptions, which in reality have fallen into a morass of personal and political degradation. And this particular litigation is a shining example of that political degradation. We should, we think, defer to the legislature's wisdom and perception, saying we know the reality, and that's why the 10th schedule, that's why they must not allow crossing the floor must not be allowed. And then Bomai, whatever may be his personal, I've already, Malas, personal this thing, I've already read that, so I will not trouble you. Then, Malas, now, para, respondents based on undisputed facts on record of incurred disqualification. I will not do that. I let my learned friend deal with it. I, Malas, actually mentioned it yesterday. Every act of theirs from the 21st onwards is an act in violation of 21A. Every act of theirs, which is undisputed. 21B, of course, but that's on, afterwards. Yes. Then, Malas, now, E is the decision of the Election Commission in the para 15 cannot efface the disqualification income. But whatever may be the consequence, that disqualification has already happened. Even if the Election Commission's order is right, which is ex facie wrong, but that's, we'll deal with it separately. This disqualification has happened. That cannot efface the disqualification. That's the purpose of this particular paragraph. So, Malas, I will. Then the order dated 27/6, interdicting proceedings before the Deputy Speaker, in effect, created a hiatus in the operation of the 10th schedule. I've already, Malas, dealt with that, so I won't trouble your lordships with that. And then the list of dates. Then the only thing I have to now, Malas, is to go back on my written submissions. On my written submissions, original written submissions. Yes. Now, Malas, I want your lordships to look at the chapter relating to whip.
In your rejoinder?
No, Malas, my
Originally.
original submissions,
Yes.
chapter relating to whip, that is PDF page 70 in my written submissions. So, lordships don't mind.
70.
70. Lordships, just have a look at it.
Chapter 7.
Yes.
Chapter 7 on whips. And Malas, they did not address your lordships on this at all. The only thing they gave was that document which I showed to your lordships yesterday.
Only one thing which they have said about
Yes.
whip is
Yes.
that they have referred to the disqualification rules.
Yes. Oh, yes, I have to deal with
And,
that.
perhaps you may want to.
I'm sorry,
look
I
at that.
in
That
my.
related to 3-1.
I'm going to show that immediately, Malas. That's my mistake. I should have, in my desire to finish quickly, Malas. Kindly go to those disqualification rules. There is compilation, Malas.
Rule you will have to.
Yes. Statute compilation. F. This is PDF, Malas, page 6. Thank you, Malas, for reminding me. I should have dealt with it.
We have some doubts, so
Yes.
Yes.
Malas, definition of leader. Your ladyship has it, my lord has it?
Yes, we have it.
Leader in relation to a legislature party means a member of the party.
What are they referring to?
He's reading Maharashtra layers this thing.
तो ठीक है, कोई बात
First bookmark,
Page
page 2,
नहीं। एक बजे कर लो।
rather 4.
516.
Definition.
तुमको भी time मिलना चाहिए।
Definition.
Oh, okay.
हाँ।
Yes. Thanks.
It's a PDF
Yes.
6.
Yes.
See, leader, lordship has that now.
Definition.
Leader in relation to a legislature party means a member of the party chosen by it as its leader. Chosen by the party as its leader. Member of the party chosen by it as its leader. Complete misreading of this definition, Maharaj. And includes any other member of the party authorized by the party to act in the absence of the leader. Authorized by the party. Consistent, Maharaj, with all my contentions. This is not in the domain of the legislature party. The party chooses the leader, the party chooses the whip. So this argument that I had thrown you out, Sunil Prabhu I had thrown you out, therefore I need not have recognized Sunil Prabhu at all on the 3rd. Because I had appointed Gogavle. Amalas, yesterday, an argument was made, how could they whip act outside the house? Amalas, what were they doing in Assam? Appointing a whip outside the house? They made me a serious argument yesterday. This is a whip. How could they do it outside the house? So you're sitting in Assam in the lap of the BJP, and you are displacing a whip which is recognized by the political party and conveyed to the speaker. And these office bearers are there on the record of the register of the assembly. And you say Gogavle is the whip. I mean, it's per se voluntarily giving up membership. You say I continue to be the leader. On what ground? You've been removed on the 21st of June itself. So how are you the leader? Well, let's kindly look at it this way for a moment. Well, supposing I say I am the party, what should I do? I should go to the party, call a meeting. There are rules of the party. Go and establish your majority in the party, and then become the chief minister. There may be no dispute in the legislature party. Take a case, Malas, where there's no dispute in the legislature party. What would a person do if he says that, look, I am the party? He will go to the party. He can't do it any other way. Now, if you are able to galvanize the support of X number of members. There may be minority, there may be majority. And then on the basis of those numbers, you destabilize an elected government and then go to the election commission. And on the basis of the fact of those very people who are subject to disqualification, get the symbol and then say, I have the party. Which of the two procedures would be constitutional? Constitutional law, members of the legislature can never be given primacy over the party. Can never be given. Because they are individual members, Group means you may actually act together. That's not relevant. So, this is one part that they relied upon. Then para 3.
3 must be read in terms of.
Yes, exactly. I was going to read that, That's at page 5. The leader of each legislature party, other than a legislative party consisting of only one member, shall within 30 days from the date of commencement of these rules, or where such legislature party is formed after such date within 30 days from the date of its formation, or in either case within such further period as the Speaker may for sufficient cause allow, furnish the following to the Speaker: a statement in writing containing the names of members of such legislature party, together with other particulars regarding such members as in Form 1, and the names and designations of the members of such party who have been authorized by it for communicating with the Speaker for the purposes of these rules. Clearly,
It is in the definition also.
Yes. Then, my Lord the Chief Justice asked a question, or one of your lordships asked him a question. Is the whip mentioned in the form? And the answer is yes. The fact is it is not. Kindly see the form now. He gave the answer as yes. Page 13.
Whip is by convention, is it?
Yes, absolutely. It's not even there. Party affiliation, that's all. Item 5. Date of election, date of signing of the form.
Which form is this?
This is Form 1,
Form 1. Name of the legislature.
That's
party,
all.
Name of the corresponding political party.
Yes. There's no question of whip. No question, that's something that's appointed by the party.
Page 5.
Page 11. Page 11, your ladyship may have. Page 11, Form 1. PDF 13. So, it's crystal clear. Which is why, they very strategically did not refer to all that I had said about the whip. Not mischievously, strategically. Huh? Yes, I was on petitioner's written submissions on this, Petitioner's written submissions, I got it. Yeah. That's at PDF, page 70.
It's for lunch because we'll relax a little.
Let me see. PDF, page 70. on whips and the role of political parties.
Yes.
So he said there's no distinction between legislature party and political party. See the definition. Subject to provisions of paragraph 4 and 5, a member of a house belonging to any political party.
Where are you reading?
Page PDF 70 in my written submissions.
On whips and the role of political parties.
Yes. Of which they didn't deal with it
You
at
have
all.
read in detail, Mr.
I'm sorry?
Well, that one you had read very much in detail.
In fact,
written
we've highlighted.
Originally, yes.
Highlighted that.
I highlighted the history, how a whip was, all that I said, but they didn't deal with it at all. Their argument was, no, the legislature party appoints the whip. And they gave that document to your lordships, which is contrary itself to the record. But that's a Rajya Sabha member appointing with it. So, I've done with this part of it. Now, a bit about Nabam Rebia, if your lordships will permit me. As far as Nabam Rebia is concerned, Nabam Rebia does not take into account the ambit of Article 179 of the Constitution and the concept of removal in 179. We'll see that. First, 179C.
Does
It
not
is
take into
removed
account
from
the
it.
concept of removal in Article 170.
Yes, removal in 179C, not dealt with at all. In that context, yes, kindly have a look. Provided that it's like not a no confidence for which no reasons have to be given.
May be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly.
Intention to move. Intention to move. Your lordships will remember the submissions that I had made. The question of moving doesn't arise. Intention to move. So that concept, is not dealt with in Nabam Rebia at all. What does Nabam Rebia say on the issue of 10 members? My learned colleague, Mr. Jethmalani, said that seemed to be an erroneous interpretation. Then members means then who are members of the House at that point in time. That will exclude people who are disqualified. But Nabam Rebia says, no, you can't change the status of the House, even if there are disqualification. In a sense, saying that you can't even deal. The Speaker can't deal with disqualification petitions. That's also an area where Nabam Rebia did not deal with it. That's the second. And the third is, just look at this notice. Please show where the notice is. Notice which we were given. Para 235 or what?
Nibam. Nabam.
No. I am talking about the concept of removal. I'm not talking about, we are not here talking about whether the article is referred to or not. No, not the ground. This is the whole point. That issue was never raised. It was me. Many things you have said happened but didn't happen. So let's not go into it. There is no discussion as to, there's a difference between notice for removal and a mere notice without any grounds for removal. See the notice here.
Yes, can we see the notice?
Yes, that's one important. Yes, I know, I've already said that. Convenience compilation, 2 mullets. Page 62 mullets, PDF. It's very interesting.
PDF page?
Page 62 mullets.
62.
Now, mullets, kindly see. Just have a bare reading of this notice. You'll find out, mullets. You realize the fallacy of the decision in Nabam.
Running into 731 pages.
कहाँ पर है notice?
PDA page 60.
This is that one, Malaz, which it is dated 21st June, but Malaz received by the secretary, the secretariat at 11:33 on 22nd June.
AM.
Yes. Says you were, my lords have it?
Yes.
You were elected as Deputy Speaker of the Maharashtra Legislative Assembly in 2019. Since February 2021, due to resignation of Nana Patole from the post of Speaker, you have been discharging functions. We all respectfully submit that you no longer have a right to continue as Deputy Speaker. What kind of notice is this? For my removal? It's well-known judgment of the Supreme Court, so they rely on Navam Revia. They misinterpret, according to me, Malaz, this could not have been the law in Naban Revia. Could never have been. They write a letter saying, now, I want to remove you. That's it. It's not a no confidence motion. It involves, Malaz, consequences, civil consequences. I am holding an office under Parliament. I am removed from that office. I am not told why I am being removed. Yes, that's why the Constitution says at the time when the Legislative Assembly is in session, remember I read that? At that time, if it is moved and it is under consideration, only on that occasion I cannot sit. I have to go down to the House and I can participate in the proceedings and put my point of view. The procedure itself tells you that inherently in this process are reasons for removal.
What you're saying is simply saying no longer enjoy the support of the majority of the House means nothing. This is what
Yes.
you're saying.
So Malaz, Nabam Rebia has to go. It's in that context that I mentioned 179C, Malaz. So Malaz, I've done with that. Now I just want to read, Malaz, their letter of the 21st of June, that resolution. Your Lordship, will just permit me. I won't take much time now, almost done. Which way is that? Convenience compilation 2, page. Section 2, page 55. That PDF 55, Malaz.
PDF 55.
55.
55.
55.
Oh, ठीक है.
55. 555 only.
Is that right? No. PDF 55. Okay. Yes, Malaz. Can you kindly have a look? Read with me this.
ये कहाँ है?
Page 42. 42 only.
42.
Yes. Page 55, volume 2, Malaz.
Yeah, page 55.
Okay.
So, Malaz, this, first of all, this is written when? When this group, whether it's 34 or 39, are sitting in Assam. They know on the 21st of June that Eknath Shinde has been removed. Right, Malaz? So it is in that context that this document is written. So obviously it's a self-serving document. It is not a document that sees the light of the day prior to 21st of June. It doesn't talk of any event prior to 21st of June. It makes some general statements that our cadres are unhappy. It refers to no such event. It refers to no such event when he has aired his views publicly prior to 21st of June. It refers to no such communication to the Chief Minister or to the party office prior to 21st of June. It's a self-serving document to justify the switch to the BJP. On account of corruption in the government. But till the other day, till 21st June, he was the minister. And he was the group leader. Sorry. And corruption is not relevant, Mullahs, as your lordships have already heard. In Boma itself says corruption not relevant even for 356. Forget about this. So, Mullahs, what's the credibility of self-serving statements of a document when you're sitting in the lap of the BJP in Assam, knowing full well that you have been removed as a group leader and that Ajay Chaudhary has been appointed? Now, Mullahs, kindly see the end of this document. PDF 58. In view of the above, I'm sorry, my lords have that. In view of the above, the members of the Maharashtra Shiv Sena Legislature Party have met today, Legislature Party, and resolved as under. Hence, it is unanimously resolved as under. It is hereby resolved that, and reaffirmed that Eknath Shinde, who was appointed as a leader of the Shiv Sena Legislature Party on 31/10, is and continues to be the leader. Why continues to be the leader? He is the leader, if he is the leader, because he knows he's been removed. And then it is hereby that Bharat Gogavle elected is appointed as the chief whip, and that Sunil Prabhu's appointment is cancelled. Well, sitting in Assam, 34 people or 39 or whatever, cancel the appointment of Sunil Prabhu. Which procedural law is this? He's been the whip since 2019. So it's a self-serving document. No credence can be placed on it. There's not a mention of a split at all. It's the decision of the legislature party. So no split, self-serving document, and relied upon to show that there was some enormous discontent that was happening, reflected nowhere in the document with respect to any fact that's stated. And governor says that this document shows I am in receipt of resolution of 21st by 34 members stating that there is enormous discontent. Resolution clearly indicates that the majority members of the Shiv Sena Legislative Party want to exist the alliance of the NCP and INC, and to that end, they have reaffirmed the appointment of the leader of Shiv Sena Legislative Party. He's recognizing a person who has been thrown out, the governor. With greatest respect, Mullah, this cannot be countenanced. You have to completely disregard this document as a self-serving document with no indication. And therefore, Mullah, Justice Venkachalaya's observations only, Mullah, reaffirm that we have reached the bottom of the barrel. So, Mullah, I mean, I didn't want to say this, Mullah. I really did not want to say this. But I'll give to the other side. You just have to read it, Mullah, where we are going in this country. Give it to my. Read, just send it to my. Just give it to the other side. I will not read it aloud, Mullah. This is a communication by the governor to Uddhav Thackeray. Just give me a few more minutes. I'll have done, Mullah. Give me just a few more minutes. During COVID times, and kindly come to the second page. Third paragraph from the bottom. Second paragraph from the top, Madhas. The last three paragraphs, just read them, Madhas. Starting from I wonder. How does the governor write these things? This is the state of the nation. Mullahs, last thing I'd like to say, and then I'm done, is that, Mullahs, the history of this court is the history of celebration of the values of the Constitution. There have been occasions where, Mullahs, like ADM Jabalpur, Mullahs, which is in dissonance with what this court has done over the years, Mullahs. I wish and hope, Mullahs, because this is an equally, Mullahs, significant case. It's a moment in the history of this court when the future of democracy will be determined. Mullahs, I am absolutely certain that without the intervention of this court, our democracy will be in danger, because no government will be allowed to survive. It is with that hope, Mullahs, that I make this plea to your lordships to allow this petition and set aside the governor's order. I'm obliged to your lordship.
Thank you, Dr. Singh. Dr. Singh, we will continue at 2 o'clock.
2 o'clock.
So how long will you take? About 1 hour?
A little bit for Dr. Yeah, let them, Mullahs.
Thank you, Mr. Sibal.
I am, Mullahs, honored by
We'll give you an hour at 2 o'clock.
deeply obliged.